Good morning. Right from the civilizations, uh, several countries, particularly, especially uh, Asian, India and Asian countries, concentrated on worksman right because that they are not only sympathetic to the workman, but also if they did not concentrate on their well-being, so there will not be any further workman to assist you. Maybe a new one, but not the old men who have expertise in assisting you. So, as an advocate, part of the society uh, and must concentrate on society interests, you must understand labor laws. I have seen several young advocates who could not get over labor laws because the labor laws is a vast one. It is not vast one. It's very simple. To understand the labor laws, you must go through the Factories Act first, because Factories Act deals with uh, so many facilities like maternity leave, providing facilities for women workers, and preventing women worker and children from attending hazardous job, etc., etc. Okay. Thereafter, Industrial Dispute Act. Industrial Dispute Act deals with the definition of workman. Section 2S deals with the definition of workman, wherein workman should not be a managing capacity. See, this is a very vital case wherein the Supreme Court recently decided the issue contrary to their earlier judgment. This is, you see, AAR 2024, Supreme Court 2744. AAR 2024, Supreme Court 2744. Bharati Airtel Limited versus AS Raghavendra. They have reversed the earlier judgment. That is most important. In Ved Prakash Gupta versus Delton Cable India Private Limited. Ved Prakash Gupta versus Delton Cable India Private Limited. AR 1984 SC 914. The Supreme Court has stated that unless and until there is power to initiate disciplinary action and power to dismiss him from service or punishing him, then otherwise they will not be come under managerial category, was the earlier decision. That was set aside by this honor Supreme Court. They say employees in high ranking position but without power to appoint, dismiss or hold disciplinary inquiry would be included within definition of workman under section 2S. Considering the nature of duties performed, he would not fall within the definition of workman. So they say it is not correct to hold that that a person who did not have power to initiate disciplinary action and remove him from service. Now the factual aspect you should understand because this contains a lot of words which may not be acquainted with you if you are not having contact with this type of companies, because nowadays these IT companies are prevailing. You see, the respondent was initially appointed as a regional business head, South Government Enterprises Services, in the year 2009. His grade was senior manager B2 scales. His annual benefit package was 22 lakhs with fixed pay of 13 lakhs 20,000, variable pay under sales incentive plan. Sales incentive plan. That is called a SIP. So thereafter, he was in charge for 4 states. uh, state of Karnataka, Tamil Nadu, Andhra Pradesh, Kerala. Uh, he is having a team comprised 4 accounts manager sales. So he subsequently seems to have resigned the post after 19 months. He approached conciliation officer stating that his resignation was not voluntary. So what to do if he is a workman? He is not workman, but if workman approaches, you have to initially approaches the conciliation officers. So he will call for the opposite party management, and the deputy commissioner of labor commissioners have ample power to call for the record, inspect the company and etc. etc. If there was a failure, then they will refer to government and government notify. If either notified or if it is not notified within stipulated time, the labor can straight away go to labor court under 10(1)(c) of the Industrial Dispute Act. Likewise, the person who resigned and challenged this resignation as not voluntary one approached the labor court. Labor court awarded, stating that he was workman in view of following the earlier judgment of Supreme Court. But single judge, High Court judge, has set aside that, holding that he was not a workman, therefore remanded back. Remanded back was challenged by division bench. Writ appeal was dismissed. Therefore, they have approached the Supreme Court. So this is the way in which you have to approach. First of all, you have to go to the conciliation officer and then labor court. If you could not get award before the labor court, single writ petition, then after writ appeal. This is one thing. Another thing, there were several other process of approaching labor court. Number one, Workmen Compensation Act. During the course of your workmanship, if you sustained any injury or your occupational disease, whatever it may be, go through the act. This Workmen Compensation Act is most vital act containing provision which is being referred to MACTOP cases and other damages cases where damages are being liquidated to cash by calculation. Thereafter, you can also Provident Fund, Contributory Provident Fund, ESA Act, and if it is disciplinary proceedings, then standard rules. If there was no rules, the Standard Rules Act contains standard rules according to which services and employees' conduct will be regularized and disciplinary action will be initiated. Then after the Trade Union Act, how the trade unions are recognized, there is a trade union. This sort of labor court laws must be understood. So you should go through the judgment deeply so that my endeavor may be successful, because I want every lawyer must understand the labor laws first, because the labor laws is pertaining to private organization. If he is a government employee, then the Article 311 constitutional rules would apply. But if he is an ordinary workman, this would apply. So first you must read Factories Act, Industrial Dispute Act, and then you have to go through ECI Act, Standard Rules Act, Trade Union Act, and Provident Fund Act. Provident Fund, they will recover salary recovery, and in turn the management must also contribute their Provident Fund. If they fail to do that, they would be prosecuted on your complaint. These all are the major things. Therefore, two things you should understand, that if he is managing some of the other than the workman, therefore even if he does not have power to initiate disciplinary proceedings, he is not workman. This is the Supreme Court judgment, AIR 2024, 2744, and Bharati Airtel Limited, AS Raghavendra. Best wishes. And one more thing I would like to invite all my friends. See, from August 8th, the court will function 10 a.m. All advocates, veteran leaders, bar council members, association leaders are sleeping. So only on 1st August they will be incited to agitate. Thereafter they will agitate because they do not have that much of work to concentrate on all these things, or reading news, updating themselves. Only on inciting somebody, they will then start doing agitations, formal agitation, placards agitation. That's all. But I am happy that courts are functioning at 10 a.m. First wishes.